Electoral Amendment Bill, which has been signed into law by President Cyril Ramaphosa, now provides for independent candidates to stand for public office at all levels of governance. Here to help us understand the legislation, we are now joined by Bulelani Mkhohliswa, a director at Nation Movement. Bulelani, good to have you, and thank you very much for your time. Despite some civil society organizations threatening to challenge this legally, the president has gone ahead to sign this into law. Firstly, are you surprised that the president did this, or is this something that you would have expected him to do?
Well, Thabo, thank you so much for having us. It's always a privilege just to speak to the nation. In terms of us being surprised as to that the president has signed this into law, we're not up to the master, to the president. And one of the major challenges in this country is that there's no separation between the party, the governing party, when the decision was taken, even in the electoral conference, that the bill must be signed, that the president was not going to do anything other than outside of what the ANC is instructing him to do.
Now, the IEC has welcomed this Electoral Amendment Bill being signed into law. What are you criticizing about? What are the key aspects that you're critical about as far as this bill is concerned?
Well, first and foremost, Thabo, the IEC was one of the respondents, and they were defending even the old electoral law that we said was unconstitutional. In fact, they were the biggest defenders. When we went to the Constitutional Court. So again, we're not surprised that they are welcoming this bill that has been signed into law. And for us, procedurally, this bill was not handled properly because a bill like this, if ever there's one law, Thabo, that affects everyone in the country, including the infant that was just born today and even yesterday, it's the electoral laws. Because the elections are the ones that actually allow us to choose leaders that are going to make decisions on our behalf for the next 5 years type of a thing, and even longer. So a bill like this was supposed to have been given proper, public consultation, particularly the ordinary citizens on the ground. They were supposed to have been engaged thoroughly. But the Home Affairs did not do just the bill itself. This bill, it went against the spirit and the letter of the judgment, because the judgment itself was designed to open up the space for more South Africans who want to make a significant contribution, not to be hindered by a membership of political parties. But what the Home Affairs portfolio, Home Affairs did was to actually make more barriers to entry, meaning that people that want to come in, whether as independents or even as a collective, are unable to do that. So even the substance of the bill itself, is actually highly questionable, and it is unconstitutional as far as we're concerned.
So, if you look at the process and the journey and the road traveled by this bill, firstly, it was debated extensively in the National Assembly, where you raised this issue of consultation, and it was given another round of consultation within the NCOP. Would you say that was still not adequate enough?
Not at all, Thabo. In fact, we would even need to ask ourselves, what is extensive in terms of the consultation? First and foremost, the judgment was handed down on the 11th of June in 2020, but only, I think, after 9 months of the judgment being handed down, did the Minister of Home Affairs start doing anything about it. Something that, is substantive, that can be said, okay, now there's a bit of movement. But not only that, it took them almost 18 months before, something concrete was put on the table. And it was at a point where we were now engaging with the Speaker to say, Speaker, we are very concerned that the 24 months is coming to an end and there's nothing much that has happened. Because we knew that Parliament and the executive, in this case the Home Affairs Portfolio Committee, were just going to focus on ticking the boxes instead of making sure that they actually allow the ordinary citizens, their inputs to come in and be considered even when the law is being amended. And those are some of the issues that we have been raising, to say the ordinary citizens were not given sufficient time to engage. Even when they did, they were not listened to. So it almost like it was a pre-packed amendment bill that was presented to us. And in spite of all the inputs, even by the civil society organizations, that was advanced. And many of them were very credible and very sound, but they were never listened to.
Well, there are some parties who are saying the bill is a good start. The reform in our electoral system, of course, is far from finished. Like the Good Party saying the electoral amendments are a step in the right direction. We are far from finished, but we should take these as a first step and a sign that we are moving into the right direction.
Well, again, you would not be too surprised. Good Party is the only party that has been brought in by the president, and they were given a ministerial position. So our sense is that they are literally looking after those interests. But the point is, the Constitutional Court had given Parliament 24 months to deal with the matter. And they were not just given 24 months. They were given a nice and a proper framework as to what would constitute a proper electoral law that will be constitutionally sound. And what we can say without any doubt is that what has been submitted and even passed by Parliament now is being promulgated into law by the President falls way short of passing the constitutional muster and even the guidelines that the Constitutional Court had given in terms of what would make a sound and a constitutional electoral law.